Welcome everyone. I'm excited to continue our series on student rights in 2017 with our discussion on protecting students from discrimination. This is a discussion, so I hope everyone feels comfortable enough to participate, ask questions, just join in. This is a subject where I have a lot of basis working on some of these issues, so I could talk forever, so please interrupt me. All right, we're going to start with a quote. This time it's not Ben Franklin. This is President Kennedy. The heart of the question is whether all Americans are to be afforded equal rights and equal opportunities, whether we are going to treat our fellow Americans as we want to be treated. Any thoughts on the quote this week? It's pretty straightforward, I know. So.
It's the golden rule.
Yep, it's the golden rule.
It is the golden rule. It is. And I think that speaks to where Kennedy was coming from. And it is largely the basis of what led to many of the laws we're going to be talking about today. Kennedy was a big proponent of the Civil Rights Act before his assassination. He wasn't always very forward about his support for civil rights. He was very much influenced by the freedom rides, the protest movement, and we got the Civil Rights Act several months after he passed away. Lyndon Johnson essentially said that the best gift they could give in terms of Kennedy's legacy was to pass the Civil Rights Act in 1964, shortly after President Kennedy was assassinated. The Civil Rights Act had a number of implications that we're really still feeling today. Democrats used to win southern states, and President Johnson knew that passing the Civil Rights Act was likely going to change that, and he was correct. The Democrats they won the presidency once over the next, 26 years? 26 years after it was passed, I believe. 28 years till Clinton won. And that was Carter winning, and that was, after a Republican president had resigned in disgrace. So it had major political implications, but President Kennedy, followed by President Johnson, thought it was the right thing to do. What we're going to be talking about today, mostly in terms of federal legislation, are Title VI of the Civil Rights Act of 1964, Title IX of the Education Amendments Act of 1972, and then we're going to talk about judicial interpretation of those acts. We're going to talk about what discrimination actually is and what's covered under those laws and who's covered under those laws. So we're also going to cover some potential protections. There's been a lot of talk recently about LGBT protections, including the transgender bathroom issues, which we have a very fiery debate right here at home up in Palatine. I think that's District 211 up there, where this has been an ongoing legal battle. There was a lot of controversy over it in the recent school board elections with a whole slate of candidates running on just that issue, essentially. We're also going to talk about religious protections a little bit, and we are going to talk about expanding protections under existing law. Before we get into that, I just want to talk a little bit about what we're not going to cover. We are not really going to cover protections for students with disabilities tonight. The reason is, when I got into this, I realized that would be...
It's a can of worms.
It is. It really is. You're talking about at least 3 federal statutes, and it's a whole different ballgame in terms of the way the protections are structured, whereas just the Civil Rights Act and Title IX were at least in the same sort of construct. So if people are really interested in protections for students with disabilities, I would be happy to do another talk on it. I think it would be really interesting. And that would also probably get a little bit farther into educational policy in terms of the actual classroom experience for students with disabilities and what's provided for them. We're also not going to go too deeply into state protections. We're going to look a lot at the federal stuff because that's where a lot of movement is right now. In Illinois, since 2006, we've had protections based on sexual orientation and gender identification. They actually define sexual orientation to include gender identity, which might not be the smoothest definition, but that is the law in Illinois. So really the question then here is, what do those protections entail, especially in terms of gender identity? That's the whole bathroom issue. Does protecting those transgender students mean allowing them choice in their bathrooms, or do schools have some control over that? So with that, let's move on. So we're going to first of all talk about existing protections. And the constitutional authority, along with some of the basis of these protections, comes from three places essentially. You have the 14th Amendment. Within the 14th Amendment, you have the Equal Protection Clause, the Due Process Clause, and then congressional authority that is expressly granted by that amendment. Section 1 of the 14th Amendment reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws." Equal protection clause covers a lot under civil rights. Hey there, welcome. The due process clause gets into privacy rights a lot, which in this context has a lot of meaning, especially as we get into LGBT protections. Finally, the fifth section of the 14th Amendment says that Congress has the power to enforce by appropriate legislation the provisions of the Equal Protection Clause, Due Process Clause. Congress also has authority under the Commerce Clause. The Commerce Clause grants Congress the authority to regulate, commerce, trade, among the states, and also international trade. So under that clause, they can do things like prevent discrimination at places of interstate accommodation, hotels, restaurants. It covers a wide range, and over time, the courts upheld. Yes.
So how come the Commerce Clause, how does it attach the congressional authority to local public schools?
Well, local public schools are different. That's going to go to federal funding.
Oh, okay.
Yeah, that's going to go to federal funding. But as we get into the private protections, and those are intertwined. Title VI, as I mentioned on the last slide, is the one that works for schools. Title VII of the Civil Rights Act works for employment, and there are other provisions that go to places of public accommodation. So the reason I get that basis in there is so that we can talk, because the context of these, even though we're talking employment in one context and schools in the other, a lot of the analysis is identical in terms of what discrimination is, who's covered under these laws. And so it attaches, though, obviously to interstate commerce, hotels, roads, and they've really stretched that very far. There's been one case since one Supreme Court case since the passage of the Civil Rights Act that reigned in the Commerce Clause at all, and that was, of course, the Affordable Health Care Act case, where Justice Roberts, writing for the court, said that was a tax and not justifiable under the Commerce Clause. Other than that, Commerce Clause is very wide, covers a lot of ground. We also have the 15th Amendment, which doesn't have much to do with what we cover today, but very important for the Civil Rights Act because they also covered voting rights under there, and that power is granted to Congress through the 15th Amendment. Any questions so far? I know I'm covering a little bit. There's a need for a little bit of basis. So as we get into the Civil Rights Act, I talked a little bit about what kind of set this up. We had the Freedom Rides, all these protests. We had Kennedy's assassination. It was a time of great upheaval. We were a decade past Brown v. Board of Education, but our schools were largely still segregated, and the ones that weren't segregated, the students were not receiving the same educations, the same opportunities based on their race. So Title VI of the Civil Rights Act says that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any program or activity receiving federal financial assistance. That, of course, means public schools. All the public schools receive federal financial assistance. I suppose the states could fund things independently, but they have not done that because it's a lot of money involved. Unlike Title VII, which, as I mentioned, covers employment discrimination, Title VI does not protect against discrimination based on sex or religion. Title VII actually includes those two. So those protections did not come from the Civil Rights Act. Now, sex is included in Title VII, and there's a little interesting history with that. Cynics believe this was an attempt to actually derail the Civil Rights Act when it was about to be passed. A gentleman from Virginia, I think he was in the House, not in Senate, he added in the protections for sex, based on sex, and indications are that he actually believed in some equality based on sex, on gender. But he was very much against the Civil Rights Act. He was out and out racist. He did not want this law to pass. So he offered this amendment in the hopes of drawing enough votes away that it wouldn't pass. He failed. So I guess he got what he wanted in terms of protections for sex, but it did pass. Now, the Civil Rights Act, you okay?
Are you all right?
We need any paper towel or anything?
Oh, okay.
All right. The Civil Rights Act says that agencies are empowered to extend federal financial agencies which are empowered to extend federal financial assistance are authorized and directed to effectuate the provisions prohibiting discrimination. What that means is the Department of Education, the Department of Justice, among others, come up with rules to enforce these laws. And that can include pulling funding or conditioning funding on schools not discriminating on those bases.
Was that the case at District 211? Were they threatening to pull federal funding?
Well, no. That one right now I think is an individual case. The departments haven't gone after them. We'll get into it a little bit. You all might have heard that the Obama administration had proffered some guidance to schools for LGBT protections. Those have actually been pulled back. So the federal government's role in these cases right now is a little bit murky, but they aren't actively pursuing that. And I think it's important to note the federal government has never actually pulled funds from any public school or university, I think under either Title VI or IX, and definitely not under Title IX. So we also have, since sex was not covered under Title VI, we have Title IX of the Educational Amendments Act of 1972, which says that no person in the United States shall on the basis of sex be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. It's essentially the same language as the Civil Rights Act, just here we include sex. Well, looking at that language, do you think that this is...
If no federal funding or money is involved, that changes the game?
What was that?
If there's no federal funding or money involved, does that change the game?
I mean, you're still going to have state laws, and states are going to... I think at this point every state would have power to enforce that. I think the bigger really not a carrot but a stick here is that the federal funding is just so massive for schools through the states. They give it to the states and the states distribute it. That
for private schools, for example.
Private schools are not don't have to follow this. They might have to follow based on other things. If they have students from out of state, for instance, I think that they would arguably be covered under the Civil Rights Act, again, because of interstate commerce. So private schools do discriminate a bit. I think we've seen that, and it's 2017, and I think the really extreme stuff we don't see as much anymore. But no, this applies to public schools and public universities.
Now, what's coming under attack now are regulations that are in to implement the act. I mean, it's just unbelievable.
Yeah, absolutely. Yeah, and I mean that's where a lot of the debate is, and that's what they get into with the guidance on the LGBT protections from the Obama administration, and then the rescission by the Trump administration. They're trying to, as the last slide showed, they have this authority to they're empowered to extend federal financial assistance. They are authorized and directed to effectuate the provisions. So that means those agencies have to come up with rules and enforce them. When agencies proffer rules, they have to go through a rulemaking process, and they still have to stay within the bounds of the law. And they're always open to attack on that, and we have seen that more recently. Yeah?
The process for getting public comment on administrative
Yeah.
rules, has there been a trend towards sort of ignoring that step and getting feedback? Because I think one of the criticisms of Title IX is that the language on, I guess, harassment has been overly broad and has
Mhm.
landed a number of men being
Yeah, there's been
denied
pushback
due
on that,
process.
certainly. There's certainly been pushback on that. I think from the school's perspective, because they are not, convicting someone of a crime, they see that they have the ability to prosecute on a lower standard. It's arguable, and there definitely has been pushback. That is one of the things that's been argued, and we'll get to sexual harassment in a second, because you might notice it doesn't directly talk about sexual harassment. Looking at the language, though, do you think that this language, it's very, very similar to the Civil Rights Act, but do you think because it's sex and not those other protected bases, is there anything inherently different about these protections? Might it do more or less?
Oh, because in the Civil Rights Act, it's not hinged on financial assistance.
It is. Well,
Oh,
it is.
Oh.
It's the language is slightly different, but it's essentially the same protection. But think about the context of school. I know I'm leaning a little. Well, what do you guys know about Title IX? What's a big impact of it?
Sports is a big one when it comes to
Right?
mind. Absolutely.
I know you don't think about it in terms of Title IX does protect against sexual harassment, discrimination, but sports initially that was the major impact for Title IX, and that it absolutely. Let me see if I have.
That's kinda why there was the explosion in women's
My
sports.
slide broke
Whether
there.
that just nudged it along, it would have happened on itself, is to be debated.
Yeah, absolutely. So when Title IX was implemented, a lot of schools did not have sports for women.
Right.
They didn't have after-school activities. When they did have facilities, they were vastly inferior. You go and look at the differences in a locker room at that time, and major, major differences. Title IX changed that. It said that schools had to have equal opportunity for male and female athletes. So what did it look at in enforcing this? It looks at, and there are 10 factors, so bear with me for a second, whether the selection of sports and levels of competition effectively accommodate the interests and abilities of members of both sexes, the provision of equipment and supplies, scheduling of games and practice times, travel and per diem allowance, opportunity to receive coaching and academic tutoring, assignment and compensation of coaches and tutors, provision of locker rooms, practice and competitive facilities, provision of medical and training facilities and services, provision of housing and dining facilities and services, and publicity. That really runs the gamut of what sports are.
First impact when they started enforcing Title IX was the budget.
Yeah.
It
Yeah.
went up
That's
tremendously.
the easiest way. There are other ways that schools can indicate that they're giving equal opportunity, but having an equal budget is the easiest way, right? If you have equal funding for your athletes based on sex, well, it's hard to argue that that's not equal.
Well, equal facilities, I mean, you gotta spend some money there too.
Oh yeah, absolutely. I mean, and one of the criticisms of Title IX in that context was that a lot of schools pulled back on male sports instead because they couldn't get the funding. But there are essentially three ways that they can comply with this. They can look at three things. The percentage of female and male athletes is proportional to the percentage of female and male athletes enrolled in the school. So again, that's the opportunities. The school has a history of continuing practice of expanding opportunities for the underrepresented sex. So say a school is 60% male and 40% female. If they keep expanding opportunities for female athletics, that's a showing that the department will accept. And finally, the school is fully and effectively meeting the athletics interests and abilities of the underrepresented sex. That's going to be a little tougher showing. They're going to have to actually show that their athletes aren't, or that their students aren't looking for more opportunities. It's really important, right? I mean, Ted nailed it with the budget. It was a big impact. And a lot of people, it certainly was an intended effect of the law, but it's very interesting today, looking in the context of discrimination, this came in to stop discrimination in schools, and it had an effect largely on the extracurriculars.
Well, the impact went beyond high school, even college.
Oh, yeah.
I mean,
College,
in
big time.
society, just,
Yeah.
I've
Yeah.
experienced that with college with my daughters.
Mhm.
The schools go out of their way to find girls to
Mhm.
give scholarships to.
Yeah.
Because there's just not enough women
Yeah.
in the sports. So if you got a daughter
Well,
to
and-
be good in some obscure your sport and it's going to win a scholarship. And you think that sounds crazy, but it's
Yeah.
a strategy.
Yeah. Well, and it's the schools say they're I mean, college athletics, D1 football and basketball, it's semi-pro. So, to support that, yeah, there's got to be a lot on the other side to continue
they
supporting that at a
have
large school.
Scholarships to women as the men.
So, yeah.
Okay, I'm not sure how this relates, but I've seen something where athletes are taking, and most of them are African Americans, they're taking like a language course in some African language or whatever. They never speak a word of it, and so the schools are basically just kind of like using these propped up academic programs in order to have college athletes.
Oh, that's certainly true. I mean, I think that probably gets outside of what we're talking about today, but in terms of educational policy and being a student athlete, I mean, I was a student athlete at a D3 school. We very much had to be students still, but I had friends at D1 schools, and it's just...
But like with him saying that there's scholarships for women athletes, it kind of makes me think that like, hey, wait a second, I'm getting cheated out of an education here.
Why?
Because I'm not a woman and...
I don't think that's...
I'm not in demand for...
But here's the thing. I mean, the scholarships, the whole thing is they have an equal number of scholarships for men and women. The competition for the men's scholarships might be more if more men are participating in sports. But they do have the same number of scholarships, and it doesn't have anything to do with their actual slots at the school, other than they have scholarships for certain slots. So the whole point is that the funding is equal. So.
Well, the other thing, it started with, of course, Northwestern wanting to have athletes to get paid because
that's
money coming into the schools.
Yeah.
Support a lot of other things.
Yeah, and I mean, it's going to be interesting to see. I don't see the D1 athletics changing anytime soon, but if they do, if you see, D1 basketball or football kind of go away, that they decide to do like a minor league track instead, it's going to have a major impact on sports, not just for the men, but for the women, because that's a major expenditure on the school's part. And if they cut it for the men, not only will they end up cutting it for the women just based on budget considerations, but otherwise they'd have to figure out a way to distribute that money to the other men's sports, and I don't think the schools would be willing to do that. So it's a very interesting dynamic there.
Oh, one question though, we know what's happening, in various schools and what the arguments are, but what's happening in court? Is this litigated very much?
In terms of the Title IX has been on the basis of funding. I don't have too much information on that because I just trying to keep it in this context of the directly discriminatory practices going on in schools. But it has been litigated a lot. The department's powers to enforce it have been upheld, but again, Title IX, they've never pulled funding from a school district or a public university. So that tells you a little bit. On the one hand, they have a lot of sway over these schools because of the money involved, and on the other hand, maybe there's a limit to how far to the types of conduct that they're going to pick up in that. So, how do you know if treatment is based on status and protected class? Any thoughts on that? So, getting away from the sports context and getting to practices in schools.
Like your gut feeling, your intuition about how you're being treated.
Yeah. How would you know if it's based on your gut? Okay. What if the courts are looking at it? What kind of factors do you think they'd look to, or an agency that's trying to enforce these laws?
Significantly disadvantaged, or
Okay, they can look at the budget.
They can look at the budget. What about like day to day? I think it might be, I know we're talking about schools, but let's put it in the employment context since, as I said, they're very related, same interpretation. Say you didn't get hired for a job, and you think it's because of your sex, or your race, or your religion. How can
You have to have concrete evidence that someone said, we're not going to hire her because she's a woman.
That's one way to do it, but that would be a facial discrimination, but you can actually prove it other ways. Any thoughts on that?
They look at if it's proportionate hiring. So there's
They
also
look at
proposals
that.
to look at statistics
what you're looking for really is comparators, right? You're looking for
comparators.
people in your position, but they're, you know, in the majority class essentially. So that's sort of what they do. If you've heard of organizations doing housing testing, that's what they're doing. They're sending a white person and a black person to try and get the same house and seeing.
I'm wondering, like, for enrollment, or even for employment, if you're denied and you suspect that it's not because of a protected class, then do you have to, like, ask the court for being able to seek evidence, or are like, how do you find?
Yeah, it
those
depends. It
comparables?
depends, and you know,
Other-
I think one of the important things here is that these are enforceable largely by agencies. There are obviously times when people go directly to court, but I always, I'll full disclosure, I go back to the employment context a lot because I interned in EEOC, an Equal Employment Opportunity Commission enforcement office. So these are the things we look for in employment discrimination. They have some power to go and investigate, and if the EEOC says we want to send an investigator in to, you know, talk to some people at your plant, you probably should let them in, right? You know, it's not.
Well, what I'm thinking is that, like, if somebody was denied employment, then are they able to ask the court or an investigator to look at the other applicants and
They
look
are,
at what their
yeah.
class is? And,
Yeah,
okay.
they would need to show some, you know, some basis for that idea. You know, they couldn't just allege it without any facts, because what you're talking about is maybe getting a subpoena or getting to discovery in a court case. So you would have to get a little ways down the line. You'd have to have, you know, like a prima facie case, but.
You haven't mentioned age.
Oh, well, and that's of course in the employment context more than, you know,
I'll
but.
tell you, there were 30 partners that
Yeah.
truly owned
Oh, yeah.
who got their jobs back
Yep.
because of age discrimination.
That's the Age Discrimination and Employment Act, the ADEA. There's been a lot of enforcement with that. That's another important one in the employment context, and it's analyzed in the same way. They're looking at comparators. They're looking at, you know, you didn't get the promotion and you're 65. Are there 30-year-olds who were in the same position as you in terms of education?
As a practical matter, though, and I know people have sued, and it's very expensive,
Mm-hmm.
and they haven't been very, very successful. Now, here's the question. You sue, you don't have the money. In each of these instances, like suits are brought, you do get attorney's fees. So that's key.
I believe you can, and again, you know, when we're talking in the school context, a lot of people, their first step often is going to be to the Department of Education to try and get the Department of Education to enforce it. In the work context, their first step is often to the EEOC, where they file a claim and try to get it to go forward. Now, those are longer processes, and they're not as direct. And people do sue, and they sue for money damages, especially in the really extreme cases. And yes, they can get attorney's fees. I think that's under all of them. I think that's under all the statutes. So, in addition to those tangible benefits, you know, in terms of enrollment, participation, employment, promotion, can you think of anything else that might be covered under these statutes? Anything else? Any other types of behavior that should protect, well, one of these protected classes?
Sexual harassment.
Sexual harassment.
Religion, clubs,
Well, so
that kind of thing.
So religion, as I said, in the employment context is covered. We'll get into it a little bit. In schools, it's not as protected. That and LGBT protections are really the two that aren't as protected.
Why wouldn't they be covered? It's
Not in the Civil Rights Act, yeah. I mean, you know, religion, you're obviously protected under the First Amendment, but we'll discuss a little later on after we go through the...
Plenty of comparatives for those examples, though.
Well, even religion, for instance, the manner of dress in a high school, I mean, it varies from
Yeah.
school district to school district.
Yeah. And, you know, obviously, we have protections under the First Amendment for religion. The question really is, do those protections go as far? Are they as direct as the Civil Rights Act or Title IX? So early cases started to cover harassment. There's one in particular, Rogers v. EEOC, which was a racial discrimination case. And what the early courts started to flesh out was this idea that the treatment in terms of harassment, so not only sexual harassment, but on any basis, it must be either severe or pervasive enough to alter the conditions of employment and create an abusive working environment. So 1 or 2 incidents of name calling or something, it's probably not going to be covered under there. And I can tell you, working at the EEOC, that's one of the things we were looking for. Is this repeated behavior? Is it happening to all the members of a class, or just one person very rarely? Is it a major infringement, or is it just name calling? Is it name calling, or are they hitting you or abusing you? Are they not giving you, well, promotion and stuff, that can get into harassment too, actually. That can play into it. So now we know that's covered. Meritor Savings Bank v. Vinson. So this case, a woman working at this bank alleged that her boss had sexually harassed her. They had a sexual relationship. She alleged that she was coerced into that. She alleged that she was raped, and she was eventually fired. She sued under Title VII of the Civil Rights Act, alleging sexual harassment. She sued not only for enforcement of that, but for damages. What do you think happened?
Her life became a living hell.
Yeah, I mean, and that's the interesting thing with employment cases, especially where you're fired or something. These cases take years. In our previous discussions, we talked about how in schools, it can be years and years. You're out of school before these cases go forward. Employment, you're out of a job.
That's why many people
I mean,
never
it's
pursue it,
just,
'cause
yeah.
Who's got the
We can
wherewithal
talk
to do it?
about general legal principles, but facts are always important in any case. And just how do you build up a case? And of course, you've got both sides
Mm-hmm.
trying to determine which are the facts.
Yeah, yeah. And so these, when I talk about these cases, I try to cover essentially the agreed upon facts. We're at the Supreme Court at that point, so I'm trying to get more into the principle based on facts that at least they could agree on. So in this case, let's assume that she was correct, that this sexual harassment had occurred.
I think the court said that she was sexually harassed, but they did not give her damages.
No, I can't remember if they gave her damages because they remanded.
Oh, they
But the court held that Title VII was not limited to economic or tangible discrimination. They found that Congress's intent was to strike at the entire spectrum of disparate treatment of men and women in employment. That's pretty big, right? And I mean, I think in 2017, it's probably a little easier for us to see that makes a lot of sense. But that was a big ruling when that came down in 1986, 31 years ago. The court recognized that the plaintiffs could establish violations of the Act by proving that discrimination based on sex has created a hostile or abusive work environment, so similar to the language for race. There are a couple of important things that come out of this. One of them, let's see here, is the looking at what that severe or pervasive means. So some of the factors they looked at: the level of offensiveness of the unwelcome acts or words, the frequency or pervasiveness of the offensive encounters, the total length of time over which the encounters occurred, and the context in which the harassing conduct occurred. So they look at all those factors. Where it lies, well, you got to kind of go into the case law and really have some strong experience to know where the courts are going to come down on that. I could not tell you right now what is going to be that trigger point, just on a clear-cut basis.
You can have an individual suing, but let's say the problem is the company and it's systemic.
Sure.
How do they handle that?
Well, systemic, so that's when you're getting into the agencies enforcing. You obviously have the EEOC for employment. You have the Departments of Education and Justice for schools. So then they're going to be getting into whether they're going to fund that school. And that's how they're essentially going to handle the systemic. I think they have the power to issue specific guidelines for a school to follow if they haven't been living up to it. So the next case, Price Waterhouse v. Hopkins. This one's pretty interesting. It's not this sexual harassment in terms of a coworker making unwanted sexual advances. In this case, she was an employee at a firm. She was an associate at a firm, Price Waterhouse, and she was passed up for promotion. Her coworkers described her as aggressive, foul-mouthed, demanding, and impatient. Let's see, during her evaluation, this is a written comment, so they actually have proof of this, said she needed a course in charm school. She was told verbally to walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. She did not get her partnership. She sued. What do you think? Is that covered under under discrimination based on sex?
I think she lost.
You think she lost?
They just didn't like her.
Well, see, and that's an interesting point. And you know, that's where we get to the comparators, because when I was at the EEOC, we'd have people come in and their boss was a real jerk. But they were a real jerk to everyone. You know, and they were a member of a protected class, but they were treating everyone poorly. So you think she lost?
I think she lost.
Let me see if I have any clues here. No, not really on this one. Well, so what the court said was that this is gender stereotyping. That they were stereotyping against her based on gender norms. And that is discrimination based on sex. So now we're starting to see a little bit of expansion of the law here from the actual terms. But you can go back and look at Vinson and that language that I quoted, right? Where they're looking for actual equality in the workplace. They're really looking for a wholesome view of this, where they want equality in the workplace for men and women. So they also establish in this where that boundary lies in terms of proof. And they explain that the employer could escape liability if they could prove that they would have made the same decision had discrimination not played a role. So that's where you get to the boss being a jerk, right? Well, that shifts the burden a little bit. After the plaintiff proves that discrimination played a role, the employer has to prove that they would have done that otherwise. So they'll look at employment evaluations, things along those lines. I think they couldn't do that for her. I think she actually won the case when it was remanded, but I'm not positive.
That sounds like it was maybe the baseline for the current transgender stuff, to say that gender norms.
Oh yeah, yeah, that's
attached to sex, like that's too much.
very much so. And that's an ongoing debate, and this is the basis for that. So it's gotten this case has gotten a lot of play recently based on that. All right. What if the perpetrators of the harassment are of the same sex as the victim? Does an element of sexual desire have to be present in this? So sexual desire, or sort of like that basis of being the opposite sex, or is that just, is it hazing? And is hazing not covered? Obviously, hazing might be covered under something else. It's an assault or something. But, is that covered under here? What do you think? I'll give you... Oh, go ahead.
I think they said that it's sexual harassment.
Let me see if I change your mind when I say that Scalia wrote the opinion.
Oh.
For the unanimous court.
We're harder on women.
Ooh,
Scalia wrote for the unanimous court,
0 for 0.
any discrimination based on sex is actionable so long as it places the victim in an objectively disadvantaged working condition, regardless of the gender of either the victim or the harasser. On KLV Sundowner Offshore Services, so that sets the precedent for analyzing same-sex harassment and sexual harassment without motivation of sexual desire. So, absolutely. The guy in the case, it was pretty bad stuff. He was on an oil rig, so sort of captive audience there. He was verbally abused. He was forcibly sodomized.
Oh, God.
And when he complained to his supervisor called him names implying that he was gay. The interesting thing is, apparently, every person in the case, victim and aggressors, were all heterosexual too. So this, again, you can seek these protections not only based on your sex, but also if you're seeking protections, for instance, LGBT protections, when they formulate the laws in the states, they protect you if you're perceived to be in that class. There's a really interesting case going on right now. A police officer, had a DNA test done, and he's a white guy, and it came back that he had black DNA. He started getting harassed based on his black DNA, and he's suing.
Where is that, in Illinois?
I think it's in Florida. Saying perception that he's black, he's being discriminated against, and that is under the law. If you're perceived, In addition, I should point out, not only if you're perceived to be in one of these protected classes, but if you're being discriminated against for associating with people of a protected class, that is also discrimination.
What if I'm
under the law.
pretending to be of a discriminated class?
Well, as long as the people perceive that you are, then you'd be under there.
There was that one gal, I can't remember her name, was in the news.
Oh, I know. Yeah, that's.
She was,
Identify
I don't know if
the
there's.
draft.
I don't know if I can think of any
Well,
legal
right.
connection with that, but that was a really
Sort of
interesting.
book.
Yeah.
Just published a book.
Did you have a question, Leon?
I was wondering, like, did she lose her job because she was outed as
She was the
white?
president of NAACP.
CP, right.
Not the president nationally. It was a
Not
chapter.
national
Yeah.
in her
she was
children.
pretty
chapter.
involved, I don't remember what it was. Yeah. So
Dolazar. Someone
So-
Dolazar.
so she lied. Well,
So-
if that's what she perceived herself, then
Well.
Well, no,
So-
it's how other people perceive
Yeah.
you.
Yeah.
It's not how you perceive
Yeah, so
yourself.
for the law, it would be how other people perceive you. So the other important thing about this, so I don't know if you noticed in that language I said, but because of sex. So that because of sex is really beyond the Price Waterhouse case. That is also largely the basis for the idea that LGBT, that sexual orientation and gender identification might be covered under sex. When it says the court said because of sex, it's very broad. The lower courts have struggled with that. And it's going to probably come to a head soon. The circuits are now covering it, and I imagine it'll get to the Supreme Court. Gebser. So this one, a student at a high school in can't remember where it was. She's having an affair with her teacher. So an adult. They hid the affair until they were caught in the school engaging in a sexual act. She sued the school. She alleged that she had been sexually harassed, and she actually sued the school for damages. What do you think?
Sexually harassed by the teacher?
By the teacher. They fired the teacher when they found
She
it when
was a
they
minor.
discovered her. She was a minor.
She won.
I don't even understand that being an issue. I mean,
She sued for damages. No, she lost.
She did?
They kept it secret. When they were caught, they fired the teacher. What the court said is that they have to. The whole point is that they have to know and not correct the problem. The school wasn't doing anything. It's this teacher who potentially engaged in it. So the party must show that the school of an official or the district who had the ability to institute a corrective action actually knew of it, and then they have to make a show that despite having that knowledge, that they didn't do that. Here we don't have that. On the other hand, this was the first case where they acknowledged, I believe, that a teacher engaging in sexual conduct with a student could be sexual harassment. How about student-on-student sexual harassment? Is the school liable for that?
If they know.
Same thing. If they know about it and they don't do anything about it.
That's correct. In this case, a 5th grade student was subjected to harassment over the course of, I think it was 6 months. She kept complaining. She sat next to the boy in a class. They wouldn't even move her out of her seat. He was grabbing her. He was making verbal advances on her and apparently other students. He was eventually charged with a crime, I think, in the juvenile courts. But the school didn't do anything. Yes, she sued and won. The school, again, yes?
Well, if you would take out the knowledge factor, then you're making it absolute liability.
Well, yeah, that's exactly right. I think there might be cases where you'd have something akin to it, where the school is just maybe not supervising a locker room, something along those lines. Maybe if they should have knowledge of it, you might have a different situation. I don't think the Supreme Court's gotten to that, but based on, I think just how they treat, especially cases with minors, they might do that. So Sandra Day O'Connor actually wrote the opinion of the court in Davis, and what she said was, "We thus conclude that funding recipients are properly held liable in damages only where they are deliberately indifferent to sexual harassment of which they have actual knowledge that is so severe, pervasive, and objectively offensive that it can be said to deprive the victims of access to the educational opportunities or benefits provided by the school." That's a pretty good summary of where we stand on this right now. I mean, that covers a lot of these concepts we've been talking about, right? Severe, pervasive, or objectively offensive, that it actually deprives them of educational opportunities. Same goes for race, Same goes for nationality. That's where we are. Not religion, not LGBT. Did I cover everything there? Yep. And that's what O'Connor had said. I didn't realize I had a slide. All right. Are sexual orientation and gender identity covered under current federal laws? So Title VII for employment, Title IX. Title IX for education. We wouldn't be in Title VI because, I don't think there's a basis. I guess I gave that away. I don't think there's a basis in Title VI for sexual orientation or gender identity. But how about Title VII for employment, Title IX for?
You think it would be covered?
You think it would be? How? Like the gender stereotyping?
Yes.
Any other thoughts? Anyone think not?
I was just hearing some presentation by a transgender person, and in a lot of these federal laws, there's protections for sexual orientation, but not gender identity. So
Yeah, that's pretty interesting. Some of the laws he said there are like explicitly. Yeah. Yeah, I mean, that's interesting. Some of the laws do explicitly. I actually think that's been corrected at this point. There, I believe, are 13 states that protect explicitly students in schools on sexual orientation and gender identity. And I think there's only one state left that only does sexual orientation. Of course, all the other states don't have any protections, so. Well, except maybe federal law. So any other thoughts on that? Any pushback against sexual orientation and gender identity being covered by those statutes?
Trump.
Well, Trump, certainly. But I mean, in terms of an actual argument, I'll play devil's advocate if no one else wants to.
Yes, please.
Okay? It's 2017. These laws have been around for 40 plus years. Why now? Did Congress actually contemplate that? This is all about what Congress intended, right? And we saw that broad language about making it equal in the workplace for men and women.
How cognizant was Congress back then of transgendered issues?
Well, or even just gay and bisexual issues, right? Because we're talking the full gamut here. We're talking sexual orientation along with gender identity. Yeah, I mean, I think, and that is a large part of the pushback is, is this something that should be explicitly in there? Now, on the other hand, we've seen they've got a pretty expansive definition of this thing, and they did think, especially with Title IX, that it was pretty broad. Title VII, as I said, got kind of thrown in as an amendment, the prohibition on discrimination based on sex. So there isn't much legislative history for that. It was just this guy throwing it in at the last minute. Title IX has a broader history, which I think has allowed them to open it up a little bit and include things like harassment.
Now, legislation actually implements the Constitution. Now, absent any legislation, are there any rights that are guaranteed under the Constitution in this area?
Well, that's interesting, and certainly the courts have not been willing to protect them with the strictest scrutiny. They haven't put them at a level with the so-called immutable characteristics like race. That might be changing, and I think the gay marriage decision, the marriage equality decision rather, probably gets towards that. But explicitly, that's one of the arguments they're trying to get in. But so far, not much beyond marriage rights and actual freedoms to have relationships. Lawrence v. Texas, obviously, which overturned laws against sodomy, and then, of course, Obergefell, which said that marriage equality is law of the land. Well, the Departments of Education and Justice have issued guidance on this. This was under President Obama last May. They said that the departments treat a student's gender identity as the student's sex for purposes of Title IX and its implementing regulations. This means that a school must not treat a transgender student differently from the way it treats other students of the same gender identity. And I pulled the gender identity part. Sexual orientation was in there as well. Well, there was a case going forward on this in Virginia. Gloucester County School Board v. Gigi. It's his initials because he is a minor. This boy, transgender boy, was allowed for, I think it was 2 months to use the boys' restroom, which is the one that he identifies with. There was some uproar from the parents, and they said that he was no longer allowed to use the communal restrooms and would need to go to a private facility that they had set up for him. He sued. This case was on its way up to the Supreme Court, and then as they were getting the briefs, they got a letter from the Trump administration that the departments were rescinding the guidance from the Obama administration. Where we go from here, I do not know. I don't know what the federal government will do on that. I have some guesses how the Trump administration might handle it. But
So
for now,
I have a question. So the Supreme Court, did they deny, because it only takes 4 Supreme Court justices to decide if they're going to take a case.
they had granted the case, and it was on its way up, and then they actually remanded it to the
Because of the rescission?
to the circuit because of the rescission, because the student was basing his case on this guidance from the Department of Education that said you have to allow transgender students to use the bathroom they identify with. Whether it gets back up there on a sort of different context right now, hard to say. I think it's a tougher argument for them to make that sexual orientation and gender identity are inherently under there. The argument that the departments make is that they're implementing rules based on this statute and that the statute's ambiguous. And I think that the fact that sexual harassment and that gender stereotyping have been brought in, I think that helps the argument that it is that there is some ambiguity. We see that it isn't just strictly based on sex.
So how do you think it'll play out? If they're providing,
Oh God, I don't know how anything's going to play out anymore.
it's hard, but if they're providing him alternative accommodations,
Well, but
it's just
But
like
it's
with
not
title.
equal.
isn't that's what I was going to say, separate but
Well,
equal, right?
It's separate.
But you also have to take into account the other people that might take offense to somebody of some other sexuality
Yeah.
coming into the boys' locker room or vice versa.
But
Yeah,
the
and
law
it's
doesn't
such
take
a-
into consideration their offense. isn't
Well,
it?
can't those students go to a private restroom?
Well, so not in a practical sense, you're going to have 90 students now all go to a private restroom.
I don't think
because
they
of
would.
the one.
I mean,
So
knowing high school students, I don't think they will. But yeah, I mean, that's certainly something to look at.
Boy walking
But-
into my daughter's locker room.
You know,
we all know the arguments.
yeah, but
So it's very interesting. To
you know, the argument is, and this is why I included the due process clause of the 14th Amendment, because we haven't talked about that much yet. Process clause is the basis for a lot of our privacy rights. That's Roe v. Wade goes under there. Access to contraception goes under there. It's privacy rights. Arguably, that student has a privacy right under the 14th Amendment to use the bathroom he identifies with. Now, obviously, there are arguments against that as well, and it's like you said, and you know, with parents, it's one of those really sensitive issues in terms of that. I don't know how it's going to come down. I don't know what the Trump administration is going to do with it. They were set to issue some very restrictive language, and apparently the president's family pulled them back on those. Don't know, could come out with it tomorrow. There's no predictability right now. I think one of the really tough things here for me, and this is, you know, I say this, and I know talking to a lot of people, this is a bipartisan concern. A lot of these issues we're just not going to get to under him or anytime soon under another president, because currently our institutions aren't functioning how they're supposed to. And just the idea of getting those institutions back up to their full functionality and sort of the checks and balances that we expect, and you know, Congress passing laws, departments enforcing laws, that could take some time. So I think that short of very concrete cases and enforcement opportunities, it's going to be some time before we have any real guidance on this. I could be wrong, but
As a practical matter, do you lawyer up or do you out in the streets protesting?
for
What's happening now, the ACLU?
Oh, yeah.
You're
well,
lawyering.
I think that you know the people are doing both, and I think that they see there's a political aspect and there's a legal aspect. These arguments are still ongoing, and I'm going to get to a very important case that just happened with that, at least based on sexual orientation. The gender identity one's tougher. I don't think we're all that close to getting a solution on that. So I think that, you know, there's the political side, and people are protesting and organizing to try and find political changes. But on the other hand, I think that there are legal avenues that they can go down in certain cases.
Now we're talking about impact in society. You had the women's march, but there were a lot of different issues covered in the women's marching.
There were, yeah. Yeah, and you know that's sort of the thing when you have any group like that, and we talk to people all the time. People are fired up on both sides. I think you can look back to 2008 and 2009 and look at the Tea Party, and it was largely people on the other side who were fired up and are still fired up. It's one thing to be angry about what's going on, and it's another to organize around issues. And you know, LGBT protections are something that people are organizing against. It's a concrete thing. But then the question is, will that continue if they have other concerns? If they're concerned about you know, issues that they see as national security threats, do they you know, take their eye off the ball in terms of discrimination protections? It's tough. There's a lot going on.
The federal government?
No, people who are fired up and looking to do something. So we're going to move on to a case that came out, I think last month, April 4th, 2017. So we're really, you know, timely here. This was a case in Indiana. A teacher or professor at Ivy Tech Community College. She is gay. She was in the parking lot before the school day. Her partner had dropped her off. They kissed goodbye, and she went about her day until she got called in. I don't know if it was the same day or later in the week. She was accused of sucking face in the parking lot, which they don't really have any evidence of that. It seemed like it was just a goodbye kiss to her partner. She started being passed up for promotion, and she was eventually fired. What do you think the Seventh Circuit did?
They protected her.
We need more detail.
Okay, let me see if...
What was the grounds for the firing?
Well, they argued that that was that was they weren't going to rehire her, but she had been getting promotions. She'd been getting promotions. They couldn't really point to anything that changed, and she suddenly stopped getting promotions. You know, they again, this is one of those where obviously the other side's going to argue a different basis. We're at the circuit court at this level, so the district court's findings were that this was in fact based on her partnership with another female.
Now, one of the things you said, you wouldn't get to talk about social media where a lot of this stuff happens.
Oh.
We
Well,
won't talk about it.
so what do you think? Do you think Miriam said she thinks the court protected her?
Sounds like it.
Yeah.
I'm gonna say on that.
So this now let me just say this is the first time that a court has done this. The circuit court has done this. They protected her, and it was a fairly strong decision in her favor. They noted that sex as a protected classification has expanded under a succession of Supreme Court cases. So that's really important, as we said, and as we get to the department interpretations. You have that Price Waterhouse case where we expand out to the gender stereotyping. We have ONCAL, so same-sex harassment, where it's not based on a sexual advance, but based on this harassment. So what the majority said is the goalposts have been moving over the years as the Supreme Court has shed more light on the scope of the language that already is in the statute, no sex discrimination. So they're trying very, very explicitly to say that, you know, this is on the base, it's because of sex, that language that the Supreme Court used in the Scalia opinion. They argued that if she were a man, and she had kissed, you know, a man kissed, or had her partner been a man, she kissed her husband goodbye, this wouldn't have happened. That's sort of that again, that gets back, yeah.
So this is on back. Did the original 3-panel?
No, I think they ruled in her favor.
So why did it go on bank with this?
I think they just wanted to, I don't know. I thought they ruled in her favor.
Because normally they go on bank when
Yeah.
the
I think they maybe
rest of the
just-
court's like,
yeah.
we don't like what you guys did.
I think they maybe just wanted to pick this one up because I don't know.
Just to make it a stronger opinion.
So what they said was that if she were a man, Ivy Tech would not have refused to promote her. And again, they couched it in gender norms and stereotyping. The interesting thing is Judge Posner concurred. He's a pretty conservative. I mean, granted, it's the economic issues that he's pretty conservative on, but he concurred. That's strong. So I think there are 2 cases. Maybe it's the Fifth and 11th Circuits right now that have similar cases. But beyond that, students are looking at this, and students' rights groups, because they see now that maybe not gender identity, but sexual orientation has been protected by a circuit court as sex discrimination. So we're going to see a student case soon. At least I think so. And we've seen some district court cases. It's going to be interesting to see what the circuit courts say. And the districts, I think, have been split on this. Again, the departments have tried to enforce it. The EEOC in the employment context has tried to argue that. And I think they represented her in this case. I'd have to double check, but we will be standing by for that.
Do you know if they asked the Supreme Court to hear this case?
I don't know if they did yet, because this just came down last month, so I haven't heard an update yet. I don't think they have. I don't think they have. I don't know if they're going to wait for the Gloucester case to go too. There's a lot that could come down the line. So, all right. Any questions? All right. Oop. Next, we're going to talk about the Student Non-Discrimination Act. This is one that I had the pleasure of working on, actually. It's been around for a while. They've been trying to pass this. When I was in law school, I was in a clinic at Georgetown called the Federal Legislation and Administrative Clinic. Each semester we had a client. Ours was the National Women's Law Center, and they were trying to advance this bill. The sponsors are Al Franken in the Senate, or at least they have been in past Congresses, and Jared Paulus in the House. The Student Non-Discrimination Act says that no student shall, on the basis of the actual or perceived sexual orientation or gender identity of such individual or of a person with whom the student associates or has associated, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. This language is almost identical to what we have in Title IX. Well, so pretty smart in terms of administering the law, at least. But does this solve the bathroom issue? If this is passed, it's not about to pass, but doesn't really solve.
Our gender identity.
Well, yeah, but can they have separate bathrooms? The interesting thing here is Title IX.
Deny the benefits of it.
Title IX actually covers some of the areas. Men's and women's facilities can be separate. They talk about dorms, I believe.
Oh, that's right.
They don't talk about bathrooms, and yet we have separate male and female bathrooms, obviously. So I don't know. I don't know that. I mean, maybe if this ever gets close to passage, they'll put something explicit in it, one way or the other. But as of right now, I don't think it necessarily answers that question. Now, this has not had too much momentum, unfortunately, in my opinion, anyway. I think, the bathroom issue aside, which I think is going to be hotly debated for a long time, the idea that students can be bullied without protection, they can be directly discriminated against in a lot of cases in schools, in states that don't have protections, based on their sexual orientation or gender identity. And it happens. We see it's a major part of the bullying epidemic. It happens. You have a question?
When was it first introduced? And who's backing it?
I think it was introduced first in 2008. I think it was introduced in 3 straight Congresses. I know it was introduced again in 2015. It has not been introduced in the new Congress. I'm not positive, though. It's been almost a decade for it. Interestingly, the Employment Non-Discrimination Act, which is the employment version of this, obviously, so that would be in addition to the Title VII protections. That one was introduced first in the earlier mid-90s. It passed the House, and it lost in the Senate 49 to 50. One vote. My clinic director had been an aide to Senator Ted Kennedy. And when she came in to be interim director, she brought in a signed copy of the vote from him. Thanks for all your help, even though it didn't pass. And she saw on the clinic wall the same signed copy because the clinic had worked on it too. So that was 90 that was in 96. And I think 2013, when the Democrats still had the Senate and the Republicans had the House, it passed the Senate and not the House. So it has now passed the House and the Senate separately. So, Student Non-Discrimination Act, it's young. It's got a while to go before we get there.
Before a law is actually passed and voted on, of course, you have hearings on it.
Uh-huh.
Has this had much hearings, or?
I think it's had a hearing. One of the major steps it had was there's a new education law. It's the Every Student Succeeds Act is the new one, I think. Yeah, the Every Student Succeeds Act is the new one that's going into force next year. It's an update on the educational amendments. It's
Child Left Behind.
replacing No Child Left Behind. Both sides hate it, which means it's probably okay. I don't know. I mean, it's one of those. When that was going through the Senate, this was offered as an amendment. And the chair of that committee, I think it was offered as an amendment on the Senate floor. And I actually went, I was a fellow on the Hill, and I went over to the Senate side to be in the gallery and watch the debate. And Al Franken gave a very impassioned defense of it. And Senator Lamar Alexander from Tennessee, who chairs the committee, said that this wasn't necessary. They thought local school districts were handling it just fine. They didn't see a problem.
Oh my gosh.
I mean, we've sent his office, or we being my clinic and the National Women's Law Center, we've sent the data on bullying, on what's happening in the states. So it's one thing for him to try and nuance and talk about maybe bathroom issues or something, but to claim that the school districts that bullying's not happening or that they're handling it, that's disingenuous in my opinion. It's really, he knows it's going on, and it's just a matter of, I think some places still don't want to have to stop discrimination, unfortunately. So that one's kind of stuck. But as I said, the states have passed some of these. In Illinois, we have pretty strong protections. Does not solve the bathroom issue, as we know, and I don't know where the Palatine case is right now. I think that's going to court, and they're going to have to make a decision, but I don't know how the federal guidance and the federal decision of the guidance changes that.
I thought the Palatine decided to, they passed some kind of rule where the transgendered folks can't choose the bathroom of their gender identity, but then they just had they just had the election. Do you know what happened to their board?
Yes, the board, there was a slate of candidates who ran essentially on this issue that they opposed that rule and thought transgender students should not be able to use the bathroom of their choice. That slate lost.
Oh, okay.
I don't think they got any in on that. They might have.
High school level?
This is at Palatine.
Palatine. It's District 211. That's Palatine, Fremd, Conant, Hoffman Estates. Yeah, big school district, second biggest in the state or something like that.
No,
biggest high school.
46 is the biggest. U46.
Outside of Chicago.
11 is the biggest high school district.
Yeah, biggest high school.
Gotcha.
So, protections based on religion. I promised we'd talk about this a little bit. Well, we have the First Amendment. What do you think? Does the First Amendment protect students from discrimination based on religion?
No.
Any other?
First Amendment,
First Amendment.
not the 15th, or
Well, 14th, first through the 14th, because the 14th is, of course, the Due Process Clause, and they have interpreted that, the Supreme Court has interpreted that to incorporate the Bill of Rights, or all the amendments and the Constitution to the states. So the First Amendment as applied to the states. We have the Free Exercise Clause, right?
Well,
Established.
There are a lot of circumstances where it has been applied in
Yeah.
schools.
Yeah, so there are protections based on religion. The Free Exercise Clause. So,
there's few things that, I think the most obvious one is sheets and the cure pen. They can't actually have a weapon at a public school. They allow them
oh
ceremonial
yeah,
dagger,
yeah.
but
Yeah. Well, and that's interesting because one of the cases that gets brought up outside of the school context a lot is the peyote cases. So the powerful psychoactive plant
you
that.
can't be stuck. You can't be school campus. though.
Well, no, but I mean, this is outside of that context. There was a, I think it was a State Department that was drug testing individuals, and two individuals who were I think they were Native American, and they were in a tribe that had religious rights involving peyote. They sued and said we should be able to have our jobs, and this is an accommodation for our religious practice. The court disagreed. They said they couldn't do that. So there are religious practices where, reasonable accommodation is the standard, and they said that wasn't a reasonable accommodation. So having a weapon in school, yeah, they've said it's not a reasonable accommodation under the First Amendment.
Are atheists protected?
Yes.
Homeschooling?
Homeschooling. In what?
Some people
Sure.
taught home rather than in school before.
I don't know if that would be the First Amendment that protects it. I'm trying to think. Right to associate. I'm not sure how they protect that, but
The issue has come up.
yeah.
Home.
I'm not. I'm honestly not sure what the basis for the protection is, but I know that they're obviously allowed to do that. You know, that you can compel school, but but homeschool as a substitute, I think, is explicitly allowed. Did you have another question? No. Okay.
Does Title III come into play?
Title.
Prohibiting access,
What was that?
prohibiting access to public facilities based on religion?
Title III of the Civil Rights Act.
Yeah.
Access. I mean, I suppose if it doesn't really in the school context. I suppose if they tried to say you weren't allowed to be in the school or something, but that's obviously narrower than the funding issue in the in Title VI, where they talk about access to the actual programs. It's the full language. Where did that go? Yeah, I don't have the full language on here, but that's narrower language than. Yeah, that's
that it was like the programming, the extracurriculars, yada yada.
Yeah, so that's a narrower protection. I don't know if it's been applied. I don't know if there have been any cases that come up like that. What I can tell you, well, so if so, you know, we see there is protection, right? The First Amendment, but are those as broad as the protections in Title VI and Title IX? No, right? I mean, you're not talking about the Department of Education pulling funding based on this. You're not talking about these sort of immediate things. It's a lot more attenuated. You're going to have to sue individually if you want to do it. You're going through a constitutional challenge here. It's going to take a long time, and you're a student. So other than a really egregious offense, I don't know if that's going to be a good option for you. I can tell you that when I was studying the Student Non-Discrimination Act and working on it, one of the questions that came up was the Anti-Defamation League wanted to get involved with this, and they're all about religious protections. There were questions about whether the Student Non-Discrimination Act could include religious protections. You see any issues there if that's the case? So we would have a bill that protects on the basis of, and this is a problem anyway because of the First Amendment, obviously. And I'm not saying a problem in a bad way. I'm just saying the courts are going to have to work on this.
I see an issue because bullying on the basis of sexual orientation, the Christians could say, "Oh, our religion is protected, and we don't believe in homosexuals and gay and lesbian and all that. So you gotta let us, harass them."
Right. Right. Well, and that's sort of this, and I don't have a good answer for it. They have not played this out too much. The only sort of analog I could come up with is in our first week we talked about free speech and substantial disruption. Mm-hmm. Maybe you get into that, but if you're in the classroom and you're talking about something and the religious belief plays into it, but it's really disparaging another student, I don't know. It's a really.
Like Jessica Alquiston to go to the schools to talk about how she sued her school for having that religious creed on their auditorium. The Illinois Family Institute went ballistic. What do you mean she's going to talk about bullying? It's not bullying. Like crazy about why are we calling out bullying? Because she was bullied for being an atheist.
Yeah.
She had to have police escorts take her from class to bathroom to locker to class. She couldn't. It was crazy.
Yeah, and
one of the things we're telling a nation of tribes, even if you use the word Christian, within Christian covers a lot of areas.
Yeah, absolutely, and
becoming more and more so segmented.
And you see really strong examples of different religious sects within a religion doing things that are sort of off the charts for other parts of that. The Westboro Baptist Church, for instance, their students, the Westboro Baptist Church, they have kids that go to public school and say some of these, well, personally, I think God hates fags. Personally, I think outrageous comments. They're protected by the First Amendment. So again, we're getting back into week one a little bit, but. Well, and then, they'd be protected if there were religious protections. So, I don't know. I mean, it's sort of a tough balance there. One last point with this that I want to make is if we, and this is going back, I actually did a presentation on LGBT rights before the election and thought things were going a little bit of a different direction on that with the Obama administration guidance. Well, say the courts do accept an interpretation that sex under Title IX, Title VII includes sexual orientation and gender identity. Well, then we could have legislation going the other way, right? That's always a possibility.
Going the other way.
Explicitly saying that sex means biological sex and not sexual orientation or gender identity. So I just wanted to bring
But
that up
sex
as a
does mean biological sex. Sex is about your genitalia. Gender is
Under-
about the
well,
culture.
but scientifically you're right, but I'm saying in terms of under the law, because Title IX just says sex, and it's been interpreted to
Right.
include, sexual harassment, things because of
Right.
sex, and now it's been interpreted by the Seventh Circuit to include sexual
So
orientation.
what do you mean the other side can argue the other thing?
I'm not saying they can I'm saying if the courts go with what the Seventh Circuit said, that opponents could try to pass legislation cutting the other way
Oh.
to actually define sex under Title IX and under Title VII
Oh,
as
I see.
That's going to throw
biological
a whole lot
sex.
of logic bombs.
so.
There's plenty of people out there who have the genitalia of one gender, but the
Or two
chromosomes
genders.
of the other.
Yes.
And
Yeah.
Intersex.
intersex people who
Yeah. Yeah.
have a chromosome that the triple X, there's
Yeah.
XXY, there's
Yeah, and there's
that's out there.
I'm not even going to say there's misunderstanding of that. There is misunderstanding of that, but a lot of people don't know that. They haven't learned about it at all. So I think that education on these issues and just talking about it is a big point. I think that a big part of why we have marriage equality now was the realization by a lot of people in the country that they have friends, relatives who are gay, who would benefit
Vice
from that.
President Cheney.
Vice President Cheney, yeah. I mean, but seriously, that was the Supreme Court. Their decision, I think, came about largely. I talked about this, I think, the last couple weeks about how you saw action in the states first. It was the states that started rolling through there. You had Hawaii and Maine and Massachusetts and Iowa, all these states that were legalizing same-sex marriage. And then the court essentially had seen that our culture had changed. That what was so it had a lot to do with expectations. So you wonder if education on some of these issues continues to change that. And I mean, especially it's a little bit hard to believe that we have same-sex marriage, we have marriage equality, but we don't have protection for sexual orientation in schools. You can get married to whoever you want, but if you're gay, you can still be bullied in
So
all
in
the
other
schools.
words, you can have two 18-year-olds in the high school who get married and they're the same sex, but they can be discriminated against at the school.
Yes, at least in the states that allow that. Yeah, that's a great point. Yeah.
Sam has read a lot of Supreme Court cases. Do they generally turn out 5-4?
On this stuff, well, I mean, we had a unanimous opinion by Scalia in there. It's been a mix. I think the sexual orientation and gender identity stuff is going to mostly come down 5-4, especially with Gorsuch in now. We'll see a lot of 5-4. Though there are rumors that Kennedy's going to retire, so who knows?
Then we'll have 6-30.
Well, no, I guess it would still be 5-4. It would just always be 5-4 in one direction if that happens soon. So
I thought Kennedy was a swing vote right now.
he is. So I'm saying it would be.
Trump replaces him.
It'll be 5-4. No, because we have the 4.
Oh, because Kennedy's a 4. He's not a 5.
No, he's the 5th. Because we have Breyer, Ruth Bader Ginsburg, Sotomayor, and Kagan, who are the four reliable liberal votes. And then Kennedy, he's always been seen as a swing conservative, but I think more recently he's been very close to the center.
The reason I bring this up, we may be going on a real roller coaster ride, depending on what our Constitution of the
Yeah,
Supreme Court.
yeah.
going down what?
a
different road?
roller coaster ride based on who's on the Supreme Court. Yeah, and I think that it's any Supreme Court decision that's 5-4. It is a little, it's a little tough. It's a tough pill to swallow a little bit that one vote could change it like that. But especially when you're dealing with a fundamental right like sexual orientation, well, something I see as a fundamental right. It's tough. It's tough to believe that someone's rights, the right of a student to be bullied or not bullied in school based on something that I think, I know some people still argue sexual orientation is not an immutable quality, but I disagree with that. I think it's really tough that one vote could switch that. Yeah.
Speaking of Gorsuch and the Supreme Court, wasn't it that you said you weren't going to get into disabilities, but
I
there
can
was
a
one
little bit.
case
Yes, the autism kid.
They ruled that
Yeah.
you have to provide an equal, not just a good education for
Yeah.
students with disabilities.
And
Yeah.
he was a
And-
dissenting vote.
Right.
Yeah.
And the Supreme Court basically said, no, you're wrong, Rosa.
Well, he had written the opinion, and the autistic student had lost, right?
Yeah, the autistic student lost.
And then the Supreme Court overturned him
Okay,
during his
okay.
confirmation hearing, which was,
Right.
yeah, that was a tough one. Obviously you can see that's part of why disabilities. We could just get into what's an accommodation for a disabled student, because you have such a broad range of disabilities, intellectual and physical, that it gets really tough. You have at least 3 laws governing what schools have to do, just at the federal level. And the context is very different. Obviously, the protections in terms of them being bullied or harassed, very similar concepts where you're looking for comparators, you're trying to see is it based on that thing. But then you get into the actual educational opportunities, and it's a whole nother ballgame.
He avoided being very specific on almost everything. He just made a general statement of all.
Well,
That was the first day.
yeah, they try to
Second day, they asked him more meaningful questions.
they try to do that ever since Bork, I guess. And appropriate day to bring up Bork, I guess, since
Yes.
he did end up firing the special prosecutor when he was working for Nixon.
Yep.
So, and now that we've brought the FBI into it, I think that was my last slide. So, yep,
that
nothing.
note.
So, any other questions or
Student discipline.
student discipline? And
We
that
should allow it,
Here's
that's
one
what.
that kind of crosses.
Corporal punishment.
Yes. Some of these kids, I'm telling you.
You know from the research that I've been trying to do that schools have been discriminatory in their issuing of sanctions in student conduct.
Mhm.
And I think it was just last September where Seattle School District basically said you can no longer give out-of-school suspensions because you are so disproportionately issuing them to.
We're getting into that
Wow.
next. We're
That's
getting into that in
next
2
big
weeks.
topic.
Oh yeah. And you know what?
100?
I think I got a lot of research I got to do before that one, but I think that I think that it would be hard to enforce that under Title VI. I think it would be hard with the discipline to enforce that it's discriminatory. Maybe in individual cases where you have an extreme punishment, but proving it's discriminatory, proving that it's systemic, takes a lot of data, a lot of time, a lot of work, and the departments haven't done that too much. They have the data out there showing that minority students face tougher discipline, and that's the basis of Senate Bill 100 in Illinois, which we're going to talk about in depth.
I'm waspy, I got suspended twice.
I don't know if I never got suspended in
Must've
high
been
school,
trouble.
maybe in
Must've been
junior high.
extreme trouble.
But we're going to talk about that because Senate Bill 100 was meant to address disproportionate punishments, and it's a lot harder to expel kids, and it's a lot harder to give them lengthy suspensions. And the idea is it's due process. It's to even out punishment across the spectrum, whether it's based on socioeconomic class, race, gender. And it's also meant to hopefully start fighting against the school to prison pipeline.
Yeah.
I'm looking forward to this topic. I live only 6 blocks from the high school and where the grammar school here is. And I do go to these meetings. There is not a session, either the high school or the grammar school, when they don't have student discipline
Yeah,
on the
yeah,
agenda.
yeah.
And it's usually in the executive session.
Yep. And that's,
I can't believe all
Yeah.
these discipline cases
Yeah.
at grammar
Yeah.
school level.
yeah, and it's tough. Well, so that's really interesting, and I'll get into it more in 2 weeks, but they did a study at a preschool.
Oh my God.
And the minority students were getting punished more harshly for the same conduct. I mean, I'm laughing to keep from crying. It's just inherent biases run deep. You're talking preschoolers.
Well, what I see, though, is the parents are not represented by attorneys.
Yeah, and that's really tough.
They're often going
Yep.
before the school board.
Yep.
When they come out, and I stay to the end, and they
Yeah.
got this look on their face like they've just been run over by a car.
Yep. And then imagine the parents that English isn't their native language. And that's a major issue. They don't have to necessarily provide an interpreter at a lot of these. That's another thing. We didn't really get into bilingual education. There are requirements under federal law for that too. But that's similar to disabilities in terms of the protection, the educational opportunities. Then you're getting into curriculum, and it's a whole nother ballgame.
Well,
So.
look at what happens. Your kid gets suspended or even expelled, and that has a tremendous effect on the family.
Yeah.
I don't know why there isn't an ombudsman or someone there to represent them.
Yep.
And
That's a
it's
great question.
downhill from
Yeah,
there.
it's a great question.
Downhill.
Yeah. And I think that you're right, and I think it's only part of it having something like Senate Bill 100, but it's a move in the right direction. But it's when a student gets suspended, it's not only that they're out of school; it's that what opportunities do they have during the day then?
Well, then
It's really
what
tough.
happens if you got a school district or a board that's zero tolerance?
Well, and so Senate Bill 100 largely outlaws zero tolerance. So,
I'm
well,
looking forward to student
me too, me too. Well, thank you all for coming, and I hope to see everyone in 2 weeks.
Thank you.
Thank you.